Good afternoon, everyone, and welcome to today's webinar, which is part of the Ulster Society's legal webinar series. It's fantastic to have so many of you joining us today to discuss what is truly a cutting-edge topic, AI in the workplace. Artificial intelligence is clearly no longer an idea from science fiction. It is now a reality in our everyday lives and in our workplaces. Relevant advances in AI technology are being embraced across industries, with many organizations seeing its potential to transform how they operate. As exciting as it is, it also brings a whole host of legal and ethical questions, particularly in terms of regulation and compliance. And with AI playing an increasingly important role in business, it is critical to understand the legal implications of its use. Many governments are considering regulatory frameworks around AI, which means that staying on the right side of the law will be more crucial than ever. We're delighted to have Byrne, who's a partner in A&L Goodbody, with us today to guide us through this topic. Aisling brings over 20 years' experience in employment law and data protection and is perfectly placed to give us a thorough and insightful look into AI regulation, its use in the workplace, and the key risks that we need to be aware of. During today's session, Aisling is going to look at the current and future regulation of AI, an overview of AI's use in the workplace, the key risks businesses need to consider, and how to ensure effective compliance. I must confess to being pretty ignorant on the topic, so I'm really looking forward to the next 50 minutes or so, and I'd encourage you all to make the most of it. So without further ado, it is my pleasure to hand you over to Aisling. Aisling, you're very welcome. Over to you.
Thanks so much, Gillian, and thanks everybody for having me today. I'm delighted to get the opportunity to speak to you about this topic. AI, it's a bit of a buzzword. Everybody's talking about it. Not everybody even realizes that it's being used in the workplace, but the reality is that most businesses are now deploying and using some form of AI, whether that be authorized or not. You know, a lot of employees are using ChatGPT, and a lot of businesses are deploying AI. And when we come on to the next slide, we can take a look at how it's being used in the world of accountancy. So a recent KPMG report did some deep diving into AI use, and it was a global survey, but 100 financial reporting executives from Ireland were included as part of that survey. And the statistics are quite interesting. You'll see them on the screen. 6 out of 10 survey respondents are either piloting or using AI in financial reporting. So it is happening. The other interesting part of this report was the fact that most respondents were saying that within the next 3 years, all of them are going to be actively using AI. And with that then comes an allocation of the IT budget. At present, respondents were saying that 10% of their IT budget was being used for AI purposes, but I expect that's only going to increase. And you'll see the statistics at the bottom of the screen in relation to the benefits of AI. So definitely being used in the world of work, and in particular in the world of accountancy. Now, with any use of technology and development, it comes with a note of caution. And some of you have probably seen a lot of the reports in the media in relation to AI when it goes wrong and how it can be misused. And that's going to be part of the focus of the session today. One of the most reported examples across the pond, it's a US example, but a business called Zillow, it was involved in a house flipping type operation. And it was a very large organization. It decided to use AI technology to predict house prices, with the result that it initially laid off a group of its employees. But the fallout from their use of AI was pretty significant. 45% was knocked off their share price, and they ended up having to make 25% of their workforce redundant, and that was 2,000 employees, when it came to light that the AI wasn't as good as it thought it was in predicting house prices, and it had a really serious impact on the company, not only in terms of workforce, but also in terms of value. So that's probably at the extreme end of the scale. But when we move on to the next slide, we'll take a look at sort of the issues that we're hoping to cover today. Firstly, going to talk about regulation of AI, and any of you that follow the news will have seen the EU AI Act is now in force. I'll talk a little bit about what's happening in the UK, and then we'll look at how AI is being used from an employment law perspective, and follow on looking at the risks in relation to that use, and hopefully give you some top tips at the end in relation to compliance and how we can all ensure that we keep our businesses safe from challenge. So on the next slide, you'll see John McCarthy. I like this picture. John McCarthy was one of the founders of AI, if you like, and you'll see from the computer pictured on the screen just how long ago that was. And he came up with a definition of AI, which you'll see at the top of the screen. Getting a computer to do things which, when done by people, are said to involve intelligence. And I like this definition because it's probably the simplest way of thinking about AI and what it can do for us in the world of work. The second definition is a little bit more wordy, and it was subject to significant debate at an EU level. It's quite lengthy, but it is the current definition in the EU AI Act. But effectively, it's a computer system that will make our jobs easier and result in outputs that would normally involve some sort of human input. And on the next slide, we will see sort of what the AI regulatory landscape looks like across the world. The EU has been at the forefront of AI regulation. There was a recognition at EU level that we needed to do something to harness and put parameters around the use of AI, particularly in relation to high-risk categories. And we'll come on to look at that, employment being one of those identified high-risk categories. But there's a lot of activity across the world in relation to AI. In the US, individual states are looking at how they might regulate AI, and other countries are looking at it on a global basis. And on the next slide, then we'll see sort of what the EU AI strategy actually is. I think they decided that they needed to sort of set some standards. And there is a focus on ethics, whatever that looks like, but to ensure that essentially fundamental rights aren't being impacted adversely by AI use. And that then in turn, if we move on to the next slide, resulted in the formulation of what's now known as the EU AI Act. It came into force on the 1st of August, and you'll see on the screen there's a sort of a staggered approach in relation to how it operates. And on the next slide, you'll see that various pieces of the AI regulation comes into force at different times. But by 2027, the entirety of the Act is going to be fully operative. And so businesses need to start preparing for that right now, given that it's now in force. On the next slide, sort of we'll see how the EU AI Act approaches the use of AI. And it has adopted a risk-based approach, which I think is useful for businesses because, in a lot of instances, the AI use can be pretty inoffensive. So it's not going to pose a great problem for businesses. But you can see with the likes of facial recognition and social scoring, why that might be completely prohibited from an EU perspective. And then you'll see education, employment, justice, immigration law being high-risk categories. So employment is definitely an area that's impacted heavily by the EU AI Act. And then on the next slide, you'll sort of ask yourselves, I suppose, post-Brexit, we're no longer in the EU, and the EU AI Act came into force after we exited the EU. So why is it important to us as UK businesses? Well, it is still important because if we are businesses in the UK that are cross-jurisdictional, if we have operations across the EU, but even if we don't, if we develop or we deploy an AI system that's used in the EU, then we will have to comply with the EU AI Act. So I suppose an easy way of thinking about it is to think back to the GDPR and data protection, and the fact that that has extraterritorial impact and effect. So even in relation to businesses in the US, if they were operating or they had users within the EU jurisdiction, they had to comply with GDPR. And the EU AI Act has the same effect and impact. And I suppose following on from that, will that then be a catalyst for regulation within the UK? And the answer to that is possibly. There was a reference to the introduction of bespoke AI legislation as part of the recent King's speech. There has been a little bit of flipping and flopping, for want of a better word, in relation to the UK's approach to AI regulation. And it's been a bit like their approach to GDPR and data protection. The UK government, up to very recently, wanted to make the UK an innovative jurisdiction where it was easy to do business. So they didn't want to over-regulate businesses in relation to how they use data, and similarly in relation to how they use AI. But if we move on to the next slide, we'll see that there has been a little bit of activity in relation to AI and regulation in the UK. So some guidance has been produced by the UK government, and for anybody involved in HR and recruitment, I would point you towards that guidance because it is very useful, even in the face of us not having an AI piece of legislation in the UK. From a general HR perspective, it's helpful, and you'll see it referenced on the screen. It's called Responsible AI in Recruitment. So lots of ideas and strategies within that in relation to how you should use AI responsibly when you're engaging in AI use in recruitment. There's been a TUC bill, so that's the Trade Union Congress. As you would expect, they have concerns about AI and how it's going to impact on the world of work, not only in relation to perhaps job losses, but also in relation to how it will actually impact on employees in the workplace. And we'll come on to look at that a little bit later in the session. With the change of government, there has been a little bit of a change in approach, and the government recently announced that it is intending to introduce some sort of AI legislation. What that's going to look like at this stage, we don't know the answer to that, but we know that the intention is to target very large businesses who are deploying large-scale use of AI. So I think the strategy for the UK government is to hit hard at very large businesses and not to concern itself with sectors, or to adopt the sort of risk approach that the EU AI has adopted. Now that might change, so keep an eye on the media and reports as to what that's going to look like. And it'll probably give us cause to do another seminar at some stage, possibly in the future. If we move on to the next slide, then we can sort of see how AI is used in the employment life cycle. Starting off with recruitment. Lots of businesses, and probably lots of you that are on this webinar today, are already using AI, whether that be to filter and sift CVs, applications. It's been used in relation to shortlisting, even in more minor ways in terms of drafting interview questions, for example, working on job descriptions. So there's no doubt that it is a beneficial and a really useful tool for businesses, and it can cut down on costs significantly. It's also useful in relation to performance management. I was involved in another session talking about AI recently, and one of the other panel members mentioned that it's being used in their business to help employees in relation to performance management. So it helps them pull all the information from the system in relation to what work they've done during the year. And so it's a tool that not only helps the employer, it can be really useful for the employee. And then moving on to think about learning and development equally, it can help in identifying maybe gaps where people could benefit from learning and development strategies and initiatives. When we get to the end of the employment sort of life cycle, it can be used in relation to workforce planning. And so, for instance, in relation to redundancy, AI can help in that process, but I think use it with caution would be our advice, because you will still need a huge element of human intervention. And when we come to look at some of the high profile cases, we can see how, AI has been used and it hasn't been used properly and has resulted in legal challenge, which none of us want to see. If we move on to the next slide, we can look at the issue of risk. And for anybody who, has dipped their toe and used ChatGPT, you'll have seen how transformative it is and how useful it is as a tool. I think the fact that it was downloaded over 1 million times within 2 months of its launch shows us just how important it is. But with that comes risk. It is an open source platform. So everything that's inputted into ChatGPT is out in the public domain. And do we want that from a business and a client perspective when there's a risk? No, the answer is clearly going to be no. So we need to be really careful about how it's used, how any of those open source AI platforms are being used in the workforce. Even when we are using AI platforms that are bespoke and that are tailored for use within your particular workforce, we need to be careful that the data inputted is data that's fit for purpose, so that it doesn't spit out incorrect data at the other end. Also, that employees are trained in relation to how they use it, and that we watch out for hallucinations. I'd always thought of hallucination having one meaning, but it now has a completely different meaning from an AI perspective. And hallucinations happen when effectively something is made up through an AI system. If we move on to the next slide, we can sort of touch on some of the recruitment risks. And I mentioned the use of AI in recruitment, really beneficial. Amazon decided to use it in recruitment. It streamlined their processes, and they were at the forefront of the use back in 2018. But what they didn't realize was that the tech was only as good as the data that was inputted into it. And so what happened was that it effectively resulted in Amazon recruiting white males because the data inputted reflected the majority of its workforce, which happened to be white and male at the time. And so there was an inherent bias then in relation to female applicants of colour. That was widely reported in the media, backfired on Amazon. They quickly withdrew and revisited the tool, and they've taken steps to fix it. But I think it demonstrates that even the biggest tech companies in the world can sometimes get this wrong. So we need to be really mindful about the data that we're actually inputting and using when we're using AI tools. If we move on to the next slide, then we can see just another more recent example of a discrimination in recruitment. Workday, this is a US case. It used screening software, and so that was effectively the first gateway for a prospective employee to gain entry into Workday as a business. What happened was that people felt that they were being rejected on the basis of race and mental health issues. So again, there can be equality and discrimination issues in relation to AI in recruitment. Now, this case is in the early stages. Who knows whether that's going to be proven, but not a good news story for Workday, whatever way you look at it, because it's been reported in the media. If we move on to the next slide, then we'll see, what some of the studies and statistics have shown, and there is concrete evidence of this through the studies, and that is particularly in relation to facial recognition. It's 99% accurate in recognizing white male faces, but when it comes to looking at faces of color, particularly Black females, there is a very high error rate. It's about 35%. So you can see that there's flaws immediately in the technology. And when we come on to look at the next case example, I think it's a really good example on the next slide. And again, it's a fairly recent case. It settled in 2024, but it involved Uber Eats. Mr. Manjang worked for Uber Eats. He was a gig economy worker, so effectively he was a food delivery driver. To pick up the work, he had to log into a platform, and Uber Eats used facial recognition to enable him to log in. He would only get the work if he was on the platform, so the facial recognition needed to work for him to be able to pick up the jobs. What happened was that he was repeatedly kicked out of the platform. He wasn't able to access the platform, which resulted in him not being able to pick up the work. Now we know there's been a huge focus on gig economy across the UK, and on the fact that it is particularly low paid sector. So it had a real impact on him. It affected the money that he was earning. And he brought a challenge. And if you look at any of the newspaper reports about this case, you will actually see pictures of the photographs that Mr. Manjang tried to upload when he went onto the platform. The pictures are all clearly Mr. Manjang, but whatever way the facial technology was working, it wasn't picking it up properly. This case was so significant that it was supported by the Equality and Human Rights Commission in the UK, because they felt that this was having a disproportionate impact, particularly on the lower paid sectors of society. Now, the case ultimately settled. I would imagine that Uber Eats are going to review their facial technology and the use of facial recognition. But again, I think the error rates show that this needs to be used with extreme caution. If we move on to the next slide, then we'll see another example of discrimination. And another theme that you'll see from the slides, hopefully, is that they tend to involve some of the big brand names. These are cases that are widely reported in the media, and none of us on this session today want to be a headline in any media platforms. So Estee Lauder, it was going through a reorg and a redundancy exercise, and it used a platform called HireVue as part of that process. And 3 makeup artists who were working on the MAC counter ended up being made redundant. And part of the redundancy process involved a video which was then put through an AI system and processed without any human intervention, it would seem. And the decision to make them redundant was based partially, at least, on this video and the recognition of facial expressions during that video. When the individuals challenged Estee Lauder's decision to make them redundant, the problem for Estee Lauder was that they couldn't actually explain their rationale. They had used a third party as part of the process, but they couldn't explain why they resulted in low scoring for these 3 people. And for anybody involved in employment law, you'll know that if you can't explain your decision making, that poses a real problem as an employer. So those cases settled. And one of the points that the makeup artist, I think, rightfully made was that she's used to applying makeup on an individual, on their face, but what she wasn't used to was explaining how she applied makeup verbally in front of a video screen. So, problematic for Estee Lauder. There was a lot of newspaper and media reports about this case. And I think it reinforces the need for there to be some sort of human oversight in the process. So had they used the videos, but had they been able to explain the scoring from the videos, for example, then they may have been in a position to better defend the challenge coming from the employees. But the problem was here that they couldn't provide an explanation. And if we move on to the next slide, we'll see sort of whistleblowing. We could spend a whole day talking about whistleblowing and, you know, the UK legislative regime in relation to whistleblowing protection. But there are protections sort of on a global basis for whistleblowing, understandably. You know, there's a real need for people to have protections, but you'll see on the screen that in June 2024, Google and OpenAI employees published a letter calling for safeguards in or around whistleblowing and new AI technology. And I suppose if we look behind that, there's maybe a nervousness on the part of employees, particularly employees who are involved in either the development or the deploying of AI technology. If they feel, for example, that it's displaying bias or that it's not operating correctly, you know, could that report then, if it's been reported back to the employer, trigger a whistleblowing complaint? Well, arguably it could, but I think what employees are looking for is probably a little bit of reassurance in or around that. There was a recent UK case in relation to whistleblowing where an employee, he was involved in basically selling an app. It was an app to GPs, which they could use to triage patients. And he sort of discovered when he was rolling out this app for use that it was having a particularly disproportionate impact on vulnerable patients that were suffering from mental health problems, either because they weren't using the app properly, because of maybe their condition, they weren't answering the questions properly, and instead of being channeled towards a GP practice to deal with their problems, they were effectively being turned the other way. He raised this with his employer and argued that he was effectively a whistleblower. Now, his case ultimately failed for various reasons, but it was more to do with the manner in which he raised the complaint rather than the substance of what he was actually complaining about. So I do see potential for AI issues to crop up in the context of whistleblowing complaints, so probably watch this space. If we move on to the next slide, then we will see data protection. And there are obvious risks in relation to AI from a data protection and data subject perspective. Some of you might have seen one of the headlines yesterday is the government has released its new iteration of the new data protection legislation. So I think it runs to over 200 pages long. We haven't had an opportunity to digest that yet, but there may be changes coming down the line from a UK data protection perspective. But for now, there are issues, and the case of Martin Birch, I think, demonstrates that. He applied for a data analyst role at Bloomberg in London, and he was asked to complete a digital assessment. Bloomberg were using an AI platform, partnering with a business called Plum, and he was rejected. His application was rejected. Mr. Birch felt that he had all of the essential criteria to be able to do this role. So he was slightly vexed at the fact that he didn't get over the first hurdle. And you'll see the quote on the screen. At that point, I got out the good old GDPR tools. He recognised that maybe there was an issue for Bloomberg in relation to their use of his information. And I won't bore you with the details of GDPR, but you need to be really careful in relation to automated decision making without human intervention. And I think it was established that automated decision making had taken place, and so there was an Article 22 breach, because there was no explicit consent from Mr. Birch for that to happen. So a useful tool for him to be able to challenge the process that had been used by Bloomberg. From an employer perspective, you can see why these platforms and this AI is being increasingly used, because if you are a business that's receiving hundreds, perhaps thousands of applications every year, it's a really cost-effective and efficient way, of cutting down on your already huge workload. So, whilst the technology is useful, I've heard people say that, technology is the enabler, but it shouldn't be your strategy. There needs to be a thought process in relation to the strategy before you deploy the technology. And on the next slide, so we'll see some further issues in relation to data protection. This example is more from a financial lens, and it was an EU case where a credit agency, Schufa, ended up giving somebody a very low scoring, to the extent then that they were denied a loan that they had applied for. The banks were ultimately making the decisions on whether to give the loan or not, but it was based on the scoring. And again, that scoring was conducted using AI. It was automated decision making without any human intervention, and that poses a problem from a data protection and a GDPR perspective. So going back to the very beginning of this session, where I've sort of said that we don't currently have any bespoke AI regulation in the UK. We do have, of course, different bits and pieces of legislation that can impact on AI use. One of them clearly being our data protection legislation, our UK Data Protection Act of 2018. So when we are using AI in any way in our business, we need to be mindful of that, not only from an employee perspective, but also from a data subject perspective. And that could be clients, customers, service users, etc. Moving on to the next slide, then we will sort of see that the ICO, that's the Information Commissioner's Office, the body with responsibility for overseeing the data protection legislation in the UK, they have got a very clear interest in AI. And at their recent Data Protection Practitioners Conference, it was a day-long conference, and they had a number of sessions focusing specifically on AI. So it's clearly a part of their focus area. In January of 2024, right back at the beginning of the year, they launched a consultation series on generative AI, recognizing, you'll see the quote, that AI is transformative for society. If it's developed and deployed responsibly. So they're clearly concerned, not only at development stage, but also at deployment stage. A lot of us on this session today will be deployers, and deployer is the terminology used under the EU AI Act. Effectively, what that means is the entity that's using the AI system. So if we are an accountancy practice and we're using an AI piece of software, we are the deployer. So in most cases, we will be the deployer. In some cases, we'll also be the developer and the deployer, where we are developing our own AI software, internally. But it needs to be deployed responsibly. So even though we don't develop the technology in a lot of cases, we still need to make sure that it's deployed in the right way. And we can see from the case examples that we've already looked at that, the deployers will be on the receiving end of most of the complaints, particularly from disgruntled employees and data subjects. So clearly an area of focus for the ICO. They also ran an investigation into My AI in May of 2024. And, what they said on foot of that was that should act as a warning shot for industry. They need to consider data protection from the outset. And if we think of AI from a data protection perspective, and we go back to what we would normally do when we're focusing on data protection, if we are introducing a new system or a new way of doing things within our business, we need to think about a data protection impact assessment. So we should apply those principles when we are looking at developing or deploying AI within our business. And on the next slide, we will see sort of a follow on from recent ICO activity in this space. You'll see in September 2024 that LinkedIn suspended its training of AI using UK user data following concerns raised by the ICO. And the concerns that the ICO really focus on is, whether the data subjects actually know that their information is being used. Have they ever consented to their data being used for training purposes in an AI model? In many cases, the answer to that question, is going to be no, and that then in turn poses problems from a data protection perspective. So you'll see the highlighted wording on the screen. Public trust is a key issue for the ICO, and that's why they're looking at this really closely. So you'll see a lot of the big name businesses, LinkedIn, Google, Meta, they're all in discussions with the ICO in relation to how they use data for AI training purposes. So on the next slide, then we'll turn our attention in a slightly different direction. So we're moving away from the employer use to look at the employee misuse. And there have been a lot of case examples in relation to this issue. The first widely reported one involves Steve Schwartz. And Steve, unfortunately, will be remembered as the US attorney that used ChatGPT to produce a list of cases which were effectively fictitious. So going back to my reference to hallucinations at the beginning of the session, ChatGPT effectively gave him a list of cases that didn't actually exist. And he then used them in a case, Mata versus Avianca. When the other side received his list of submissions with the cases, I'd imagine that they scratched their heads and said, gosh, we're really behind the curve because we've never heard of these cases. And once they did a little bit of digging, I think they too realised that they didn't exist. Very quickly came to the attention of the judge and resulted in a sanctions order being issued against Mr. Schwartz. But, he's now in the unfortunate position of being, one of the first people in the US courts to be involved in a case like this. And I suppose he'll be forever remembered for this. So not quite the legacy you would want as an attorney. And then equally another case, Kong Che, it involved 2 AI hallucinations in a court application, which again resulted in a reprimand. So I watched a discussion, a panel discussion on AI recently, and one of the panelists, I think, made a very good observation in relation to how you should approach AI, and their advice was to treat it in the same way as you would sort of a drunk intern student. So whilst they're intelligent and they may have good skills, you can't rely completely on what they do. It does need a certain amount of human oversight and intervention at all times. If we move on to the next slide, we'll see sort of another, again, big brand name case example of employee misuse. In this case, Samsung was reported in the media quite widely. Some of their employees accidentally shared confidential information using ChatGPT. A lot of businesses actually prohibit the use of ChatGPT because of the risks that it poses, where employees inadvertently input information, whether that be sensitive financial information, client data, information about other employees. All of it poses a risk. So the information is now out in the public domain. because of the open source nature, of course, of ChatGPT. So Samsung can't really get that information back. And that is the issue for businesses. If you're going to use AI, you need to make sure that it's done in a way that protects your business. So there needs to be boundaries. A&L Goodbody, for example, we've recently deployed an AI tool called Harvey. It's a bespoke legal tool and it's a closed source network. So, anything that we input into Harvey is protected, so it's confidential. So we have the reassurance then that nothing is going to go out into the public domain. And from my own personal perspective, I have to say that it's hugely beneficial. But like that, from an employment law perspective, several times it's referenced the Equality Act, for example, of 2010. Even though I've said, in my question that I'm talking about the Northern Irish employment law landscape. So again, the technology can get things wrong and we need to be very mindful of that. Moving on to the next slide, we'll see this is a very recent example of employee misuse and quite a serious one. An Australian case, September 2024, where the Victoria Child Protection Agency banned AI use by employees because an employee inputted the personal information of a vulnerable child and used that to draft a case report. So again, that information was inputted into ChatGPT. That is very sensitive, special category personal data from, a UK data protection perspective. That should never be shared outside an organisation. And the use of ChatGPT was detected ultimately by the employer because of the non-standard language and inappropriate sentence structures. And I don't know about people who are on this session today, but I have received emails and correspondence from individuals where I have a really strong suspicion that it's been generated by AI and technology. And so that sort of reinforces the point that you'll see on the screen with non-standard language and inappropriate sentence structures. Now that is likely to improve as the technology develops, so it's going to be less obvious, but it was clearly obvious, in this particular case in Australia. If we move on to the next slide, this is always the scary part, I think, for businesses, and we saw it when GDPR came into force. It was really the fine regime that terrified businesses when they saw what the financial consequences could be for getting it wrong. And again, I think that's why the EU is suggesting a fine structure that you'll see on the screen. A lot greater than we saw with GDPR, where the maximum fine was 20 million euro or 4% of worldwide annual turnover, whichever is greater. Let's see, 35 million euro or 7% of annual worldwide turnover. So potentially massive fines, particularly for the very large organisations. Now, that only applies in relation to placing a prohibited AI system on the market. And so, hopefully it's there as more a deterrent rather than something that's actually going to be operational. But even when we look at the next tier of fines, we will see that 15 million euro or 3% of annual worldwide turnover, still a very high potential fine in the context of a worldwide business. So, that fine could be applied in relation to high risk use of AI models. So we still need to be really mindful of that and on the fine regime. Now, from a UK perspective, we don't have the legislation, so we don't know yet whether we're going to see a similar fine structure. But if we are an organisation that's operating within the UK jurisdiction, but we deploy technology or we have users across the EU, we still need to be mindful of the EU fine regime. And then if we move on, you'll be glad to hear we're nearing the end of the session and thinking about our road to compliance. And I think a good approach is to think of it in the same way as we have traditionally approached data protection compliance. And, we've seen that, AI is a lot bigger than data protection, of course. It encompasses a lot more, from a legal and a practical perspective. But the tools that we deploy in relation to data protection compliance are really useful, I think, when it comes to AI compliance. So when we think about the life cycle, and we're thinking about using AI, what are we saying in our privacy notices to data subjects? We should be referencing our AI use. So even at recruitment stage, from an employment law perspective, if we have a privacy notice that we issue to a candidate and we are going to use AI as part of our recruitment process, we should be referencing that. So that's probably a good place to start. Where we are thinking of using AI technology and we are sense checking, are we doing our due diligence in relation to the AI platforms that we're going to use? It sounds pretty straightforward, but what reassurance are we getting from the technology company that AI platform is going to be fit for purpose and it's not going to display discrimination, bias, or any other issues that could pose a problem for your business? So testing the software is important. Informing and consulting your staff. If you are going to use AI technology in the workplace, you need to tell staff that you're going to do it and in what way you're going to use it. Because the worst thing that can happen in the workforce is for things to happen without people knowing about it. Any employer on this session will know that that's a key part. Bringing people along in your journey, being transparent, being open, telling them what you're going to do, how you're going to use it is always half the battle. If you're deploying AI technology and you are inputting data, think about the data that you're inputting. We go way back to the beginning of the session and we think about the Estee Lauder cases and other cases in Amazon, for example. What data are you using to train the AI model? Human intervention. There should be some. I know AI technology is being deployed to, in a lot of cases, avoid having to use humans. But I think some sort of human involvement is going to be needed just to make sure that everything continues to operate properly and that there are no risks to the business. Auditing is probably important. Your technology might work for a while, then issues might arise. So in the same way as you would with a data protection compliance program, you will audit the use of your technology and review. And then, lawyers love a paper trail in the same way as I think accountants also love a paper trail or some sort of an IT footprint, as we're all moving away from paper. But, some sort of paper trail or IT spreadsheet that shows that you have taken these steps, you've tried to mitigate any risks in your deploying of AI will always stand you in good stead if you are subject to some sort of challenge. So I think that's the end of the session, and I know we've covered a lot, but hopefully there's some useful takeaways, and happy to take any questions.
Thanks very much, Aisling. Very insightful, and probably a bit alarming as well. So, look, just I have a question here in the chat box. Do we need clauses in terms of employment which prohibit the use of chat, GPT, etc. by employees without specific permission in each case?
Short answer, I think yes.
Yeah.
A lot of businesses and organizations are now rolling out and introducing an AI policy because as is the case with every policy and rule that you have in the workplace, if you don't tell employees what the expectations are and what they are and aren't allowed to do, it will give them a get out, if an issue arises. So if you don't tell people expressly that they're not permitted to use ChatGPT, now there's a counter argument that everybody should know that they shouldn't be using ChatGPT and uploading any kind of, internal information, data subject information, financial data. But the best way to be able to deal with that situation is to have a policy and to be explicit in what your requirements are as a business. Yeah.
Yeah. Okay. And from an HR perspective, the question is, can AI really take the human out of human resources? I'm guessing that from some of your later slides, that's kind of covered, but
yeah, I just short answer again, I don't think it can, and because human is such a part of the HR job and interaction, and humans are so different. I don't think AI will replace AI, but what it'll do will be to streamline a lot of HR practices and functions. So when we think back about the examples and the use in recruitment, it's a tool that's going to help a lot of HR practitioners, and it's going to be, transformative, but it's definitely not going to do away with the need for a HR function in a business.
yeah. Okay, and in the absence of UK legislation, how should businesses best protect themselves from any potential challenge?
Yeah, so I think, the EU AI Act, whilst it doesn't apply in the UK, it's a good sort of gauge as to what businesses are going to expect, because, a lot of your clients will be EU based, perhaps. So there'll be expectations that if they're going to have to comply with the EU AI Act, they'll expect you to do likewise. So maybe looking at the EU AI Act, but with the knowledge that the intention of the UK isn't to replicate that at the moment, but it's probably a good, sort of starting place, to think about how you should regulate, and then just comply with your data protection obligations, because a lot of these issues arise in relation to data misuse. And if you're involved in the world of HR and recruitment, that UK government guidance on recruitment is really helpful. Whilst it isn't a piece of legislation, it's definitely got some really good practical tips in how you should approach the use of AI in recruitment.
So stick to the guidance and stick to what's there for other jurisdictions. Question here, ChatGPT is open source, so obviously a problem with private information. What's the status with Microsoft's Copilot?
So as far, I'm far from a techie, I have to confess. And I know Copilot is being used by a lot of organizations. So, I think there is a mechanism whereby you can protect your information in a much better way than you can with ChatGPT. I think, ChatGPT is still a big risk to businesses. But I know, a number of our clients are using Copilot. So yeah, it's useful. But you just need to satisfy yourselves as businesses. Is it open or closed source? That's the sort of part of the due diligence before you decide to deploy. So I suppose it's going back to the point about a bit like the data protection impact assessment. It'll be an AI impact assessment. Look at what you're using. Do your due diligence on the technology. Will your business be protected? Before you decide to roll it out across the organization and permit use.
Okay. There are no further questions just now. I don't see any activity in the chat other than to say great session with lots of practical cases. Thank you. So no, nothing else coming through. I think we can give everybody a few minutes back in their diary. Aisling, thank you so much. That was really interesting. I'm sure it's given people a lot to think about. Hopefully it doesn't keep anybody awake this evening. So listen, folks, I hope you've enjoyed the session and taken something useful, and hopefully we'll see you all again very soon. Thank you.
And I think, Gillian, my parting shot would be, whilst yes, there are some scary parts of this, it's going to be transformative. It's all going to be really beneficial, and we're going to reflect back and think, why were we scared about AI use? Ultimately, I think.
Yeah.
Well, thanks, everybody.
Okay, thanks very much.
Good day.
Cheerio, folks.